First District Court of Appeals now in session. All who have business before this court draw near, give attention, you shall be heard. May God save these United States, the great state of Florida, this honorable court.
Thank you. You may be seated. We've got a leaky cup. Mr. Marshall? I'm sorry. I think we've got a leaky cup here. Not a big deal. I just don't want it to continue to run. Put it in another one.
I'm sorry about that.
Perfect. Perfect. All right. Just put this over here.
Yeah, I'll take it.
Okay, welcome to the First District Court of Appeal. Before we get started, I want to congratulate Judge Treadwell on his appointment to the bench. He was appointed in May, so we've been serving together for a few months now, but today is his first set of oral arguments. So congratulations, welcome. It is indeed an honor to serve with you.
Thank you, and counsel, today I may be more nervous than you are.
Fair enough. With that, we will turn to our docket. We have two cases today. We will take them in the order in which they appear on the docket. First up is Mavis Tire and Brakes and Liberty Mutual Group versus Albert Lowry, 242458. Counsel for the appellants, you may proceed when you're ready.
Thank you. Hinda Klein here on behalf of the appellants. I'd like to reserve 5 minutes for rebuttal.
So noted.
We've raised 3 issues on appeal. The first is that the JCC erred in awarding treatment for Lowry's alleged hernia after finding that he had failed to present sufficient evidence that his work-related accident caused those hernias. Now, it's black letter law that the claimant has the sole burden of proof on causation. And in fact, the JCC, in his final order, specifically says, having considered the evidence before me, there is insufficient evidence in this record to allow the determination that the claimant has sustained hernias as a result of the workplace accident. Nevertheless, the JCC then awarded an evaluation and potential treatment of the hernias. Essentially, the JCC put the cart before the horse and found that there was no MCC between the hernia and the workplace accident, in which case the JCC erred as a matter of law in awarding treatment for that alleged condition. And I say alleged condition because the record on that is extremely limited. There is a radiographic report indicating that there were a couple of hernias discovered during a CAT scan, but that was 20 months after the accident in question.
Counsel, so I think even the claimant's attorney conceded that the order was inartfully worded, and perhaps there is some inconsistency. So you did note in the decretal portion of the order that there was an authorization for evaluation and treatment. But in an earlier part of the order, I read it to be not so definitive on the treatment part. The order said that the award was to determine if, in fact, he has a hernia or hernias, and if so, whether the workplace accident is the MCC, adding that if the accident is the MCC, then he would be entitled to treatment. Is there any room between that statement and then the decretal portion to suggest that perhaps the treatment portion wasn't truly ripe at that point?
I don't think so, because once the JCC determined that it was going to consider the PFB for both evaluation and treatment, and then found that there was insufficient evidence. At that point, it was ripe, it was decided, and the JCCs then, I guess if it were a court opinion, I would call it dicta almost, that if after an evaluation, a physician then determined that there was in fact a hernia, then the physician would be to determine whether or not there was causation. That's basically saying the physician is going to make what is the JCC's decision. And the JCC very clearly said, I don't find any evidence of causation here. And once the JCC decided that, everything else is basically irrelevant.
But isn't the context, the broader, bless you, context of that statement that the doctors had all testified that really this is not our area of expertise. He needs to be treated or evaluated by a general surgeon in order to have that information available to determine causation.
Oh, yes, they absolutely did testify like that. And the claimant's attorney at that point could have dismissed it, could have moved for a continuance, could have asked the court, the JCC, for another IME. There are a number of things that could have happened that did not. So it went to the JCC on this record where all of the medical experts testified that they were not appropriately specialized to be able to diagnose the hernias. That was the claimant's choice. And having made that choice, the claimant has to live with it. And the JCC's decision that there simply wasn't any evidence on MCC is binding on the claimant. And I would submit that anything after that basically is irrelevant. And the court was clearly in error in ordering, first of all, delegating the JCC's authority, sole authority to decide MCC, to a future physician. There's just no authority for that, and this court has reversed in two cases, the Gulf Life Insurance versus Giddinell and Consultants and Designers versus Brown. This court has reversed similar findings on the same basis. So we would submit that the JCC's order that basically it does not reserve jurisdiction, but basically says in the event some future doctor comes in here and says there's a relationship, then I'll think about it. Or I will let the doctor then perform that treatment. So that is a clear error of law, and we would submit that under all circumstances, this court must reverse the JCC's order with respect to the treatment. Now, having found on the record that there was no MCC at a duly noticed hearing on that specific issue, the court then couldn't grant the request for an evaluation because basically the issue was moot. If the evaluation determined that there was in fact a hernia, the JCC has already determined there's no MCC. So our second point on appeal is that this court should reverse the JCC's order with respect to the granting of the request for the evaluation. And finally, and I think this is probably part of that second issue, namely whether the JCC erred in granting an evaluation, we submit that the JCC failed to apply the correct legal standard. Because of the way this case was litigated, it was not litigated to determine whether or not an evaluation was necessary to discern whether or not the claimant's condition was related to the low back that was injured in this accident. And in fact, opposing counsel has not argued that in their brief. It was litigated as if it were a freestanding claim for benefits, and those benefits being the evaluation.
Counsel, let me ask you a pragmatic question. So if this claimant continues to have these symptoms, what is the procedural path to getting an evaluation? Can't ever get an evaluation now because of the order in which these things were decided?
That's correct. It would be
Just
res
out of
judicata,
luck.
but of course, he can always get an evaluation separate and apart from workers' compensation. Just can't do it this way. And I think Judge Ray, in the MBM case that you were on, we had a similar situation where 4 years after the accident, the claimant sought an evaluation to determine whether or not head and neck condition was related to an accident, separate and apart from the right shoulder that had been accepted as compensable. The JCC awarded those benefits, but on appeal, this court reversed because the claimant failed to prove that the accident was the cause of the head and neck condition. Again, it was entirely separate and distinct from the argument that's typically made that an evaluation is appropriate where the condition may relate to the treatment or the condition already being treated. And under this court's decision in the MBM case, it's clear that the JCC erred in ruling that there was an entitlement to an evaluation under these circumstances.
Let me go back just to the order itself. Had the JCC, in your view, expressly reserved jurisdiction on the treatment, would we be here? Would you be here arguing this case?
No.
Okay. So it seems to me the motion for employer carrier's motion for rehearing was not quite as precise as the briefs. I mean, the arguments are made very clearly in the brief that the JCC went a step too far in authorizing treatment. When I read the motion for a hearing, or at least when I read the order denying it, it seemed like the JCC was perhaps either misunderstanding what the argument was or understood it and ruled for a different reason, because he really was focusing on Granger's applicability to the evaluation part of it. So maybe you can help connect the dots for me by reminding us what you argued in your motion for rehearing and how that relates to the argument you're now making on appeal.
Okay. What we argued in rehearing with respect to, it was mostly regarding the JCC's order on treatment, not the evaluation per se. But it did argue that there was an inconsistency in finding that that there was no connection between the hernias and the accident, and then nevertheless ordering an evaluation and treatment. Mm-hmm. So we had brought that inconsistency to the JCC, and I think Your Honor is correct that the JCC did not appear to really understand that argument and did rely on Granger, which was a situation where only the issue of whether there should be an evaluation was before the JCC, not the issue of whether or not any potential treatment was caused by the underlying workplace accident. So Granger is simply distinguishable on those grounds. And certainly, had we been here just arguing about evaluation, that might be on point. But since the court lumped them together and said evaluation and potential treatment, the court's order should be reversed in its entirety.
Is it your position, like, had claimant had the opportunity to do this all over? I don't think this is your position. I want to make sure that a claimant would have to file a separate PFB first on the authorization for evaluation, have that go through the process, and then come back and file a separate PFB for authorization for treatment? Is that how you see the process should play out?
I believe so, yes. I mean, because it's not apparent that there was any relationship between the hernia and the actual treatment that the claimant was receiving for the low back injury, I believe that under those circumstances, there should have been a separate consideration of the evaluation first, and then if there was any kind of evidence of relationship, then a petition for the treatment.
Is that inconsistent with the efficient resolution of workers' comp benefits to have these bifurcated PFBs when, in reality, each one can take months to get through the process? Is that kind of, is that process consistent with just having one PFB for both and then perhaps having the JCC reserve jurisdiction if needed? If it gets to final hearing and the authorization for evaluation hasn't already been approved or dealt with?
Well, I don't disagree that probably if there had been a single PFB and a reservation of jurisdiction, that might be more efficient. So I believe that the JCC could have done it either way, but didn't do it either way in this case. If the court has no further questions, I will reserve the remainder of my time. Thank you.
May it please the court. I'm Mark Tovey from Miami, along with co-counsel Holly Akers, who is also trial counsel on behalf of Mr. Lowry, the appellee. I think you've already gotten right to the meat of the matter, which is that the judge of compensation claims ruled that an evaluation was appropriate because there's still a question as to what is causing Mr. Lowry's complaints, the complaints that he's had since the accident. The judge references causation, and he's not really clear on whether he's saying the causation to the industrial accident or the causation to the symptoms that are resulting from the industrial accident, which the employer carrier is already treating. The doctors who have seen the claimant, none of whom are hernia specialists, have all been treating complaints that overlap with the possibility of a hernia. And that's where this is an intersection that is different from the other cases that are referenced by the appellants.
So, but counsel, would you concede that the judge's language in the decretal portion of the order that says that he is authorized to evaluate and treat claimant's condition is problematic, is a step too far, at least the treat portion?
Yes, because it's inconsistent with what the judge was explaining throughout his order and also in his order on rehearing. The judge, and I think Your Honor said it earlier, Judge Ray, when you said that the judge seemed to be focused on there needs to be an extra step. Is there a hernia? The judge never specifically found that there were hernias. He did say in his order, based upon the records and evidence, there is little dispute that claimant does in fact have a hernia or hernias, but he doesn't make that as a finding. There's a CT in the Shands records that shows the hernia, but there's also records in Shands at 550, record 550 that says there's no inguinal hernia. Then there's on the record, page 638, the Acumen MRI of the pelvis of March 16, 2023, and there were no groin hernias found there. And Dr. Rogozhinsky explained it when he was in his initial record. He's the authorized treating spine surgeon who was ultimately brought into this case. He first evaluated the claimant in November of 2023. And he indicated, I've asked them to retrieve the recent EMG and NCVs of the lower extremities and CT scans documenting the presence of inguinal hernias. I'm also recommending repeat MRIs of the lumbar spine and left hip. If repeat MRI of the left hip does not demonstrate any acute findings or significant hip pathology to explain his groin pain, he will likely need a general surgery consult to evaluate him for a left inguinal hernia, which would be the likely etiology of his groin pain. The employer carriers accepted lumbar radiculopathy as one of the conditions accepted on the pretrial stipulation. That's at the record at 553. Lumbar radiculopathy means that it's leaving the lumbar area and it's going other places. And Dr. Brown has a pain chart in the record on page 923 that shows that part of where the claimant is complaining about his pain is the back on the left side, and it comes around to the front in the area where you would find an inguinal hernia. So this is the condition they've been treating all along. The appellant suggests that because the judge awarded the treatment, that that's going to absolutely obliterate the claimant's ability to get an evaluation or to ever get anything related to the possible cause here because of that. That just wouldn't work specifically in this case, but it won't work in the workers' compensation system in general. Dr. Rogochinsky, after making that remark, then got those additional scans, and then he said, so my in deposition, this is at the record 205 and 206, so my diagnosis were unchanged, and in my disposition now, having reviewed these additional studies, I formulated the following opinions. With regard to the left hip pain, he's undergone previous multiple left SI joint injections, an intra-articular left hip joint injection, and PRP injection of the, a lot of medical, obturator muscle. He has continued left hip and groin pain in spite of these interventions. He has underlying pre-existing femoral acetabular impingement from a degenerative labral tear with no reported benefit from intra-articular injection. I'm getting to the good part, I promise. Current imaging does not establish any other traumatic musculoskeletal related sources for his hip pain. There remains a possibility of a left inguinal hernia as a source of his left hip pain. And in light of the conflicting imaging establishing a left inguinal hernia on CT scan, but no hernia noted on pelvic MRI or ultrasound, I recommend that he be evaluated by a general surgeon to assess whether a left inguinal hernia is present, and if it is, a pain generator contributing to his current symptoms. And that's why this case is so much similar to Granger than it is to the other cases. Because in Granger, the claimant was being treated for carpal tunnel syndrome. The physician was finding other complaints that didn't appear to be related to carpal tunnel syndrome, but the physician wasn't sure and asked for that referral to a neurologist to determine whether or not they are related. That's what's happening here. The complaints that the claimant has are the same that could be evoked from a hernia, but none of the physicians have evaluated for that. And so Dr. Rogochinsky is saying, let's go ahead and evaluate for that, and if it's there, we need to deal with it. That'll be the next step. But if it's not there, that's the end of the decision-making tree.
Well, so let's just go back to some of the language in the orders. We have the decretal portion that references treatment, and then earlier in the order, I think this is paragraph 6, the JCC says, if it is determined that the accident was the major contributing cause of any hernia, claimant would then be entitled to treatment by that general surgeon as is determined to be medically reasonable and necessary. Isn't that too putting the cart before the horse? And doesn't causation, in your mind, still need to go back to the JCC?
The JCC should make the ultimate decision on causation. It should not be, the doctor can opine on it, but the JCC should decide it. However, if the doctor opines that the major contributing cause of the condition is in fact the industrial accident, the employer carrier can say, okay, and just provide the treatment. It doesn't need to go back to the judge. It can either be decided because it's accepted or because the judge determines it's accepted. But I agree, it should not be decided unilaterally outside of the judge by a doctor.
Right. I mean, so at a minimum, I mean, just to make sure that all the parties are on the same page with respect to this order, wouldn't it be necessary to reverse or vacate the portion of the order that references authorization for treatment? Maybe there's other problems that the employer council believes that, need to be addressed, but at a minimum, don't we need to have that issue addressed?
I've gone back and forth on this because it seems like the logical, reasonable way to handle this. On the other hand, there's no treatment at issue. So there's no prejudicial error that is harming the employer carrier. They're not being ordered to do anything other than provide the evaluation. At that point, they have made it clear that they don't believe, that causation has not been determined. The judge made it clear that he has not determined
So
causation.
is your argument here on causation kind of res judicata, so we won't see these parties again on this issue if there's a dispute about whether or not they can raise causation?
Well, I'm not sure. I was concerned that the res judicata is being applied here before there's been an order. That seemed to be what the appellants were trying to do. They said, okay, well, the judge didn't make a finding on causation, and so now the claimant is res judicata. And there was, no time to do anything about that. Whereas what has happened here is the judge has ruled, I'm just awarding an evaluation. And kind of and if necessary, and if related, and a lot of ands, ifs, but nothing definitive, and so there's no award there. So the employer carrier is not being required to provide a hernia surgery yet. They would have the opportunity, if treatment is recommended, to say to the judge, we don't think that it's causally related. We don't think it's medically necessary. They have all of the various options still available to them. So as far as the prejudicial effect of this order being affirmed, there really isn't one. There's no indication that the judge, well, there is some indication, but it's mixed indication that the judge actually addressed causation. The judge had an interesting exchange with counsel during the closing argument. The judge said, let me interrupt you. Whether the hernia, there is, and I apologize, this is on transcript page 69 and 70. Let me interrupt you. Whether the hernia, there isn't a hernia that's been diagnosed, but, Ms. Akers, not by the authorized treating doctor, the court. So I can't make a finding that the accident's a major contributing cause of something if it hasn't been diagnosed yet, other than perhaps on the CT scan, correct, Ms. Akers? Well, Dr. Rogachinsky does address it and basically does a hypothetical and does say that the work accident is the major contributing cause. The court, if the hernia exists and he doesn't do hernias, so he's not diagnosing a hernia, correct? Ms. Akers, he listed it as one of his diagnoses. I would probably agree with you that I don't think he's qualified really to do so. The judge also indicated in his order that there was a history of the hernia. So I don't know that there's a diagnosis in this case that there is in fact a hernia. And so when the judge hasn't made a finding that there is a diagnosis, that there is a hernia, it would be, there's no prejudice as to whether or not the employer carrier is going to provide treatment. And the judge is basically saying, this issue isn't ripe because I don't even know if there's a hernia. How can I rule on causation of a condition that I don't think has been established? So for those reasons, the affirmation of this judge's order wouldn't cause a problem. And it's on page 23 where the record page 23 where the judge says included in his report is a history of the inguinal hernia.
Mr. Tobey, elsewhere in your answer brief, I'm looking at pages 14 and 17, you argue that treatment can be awarded without a finding of causation based on the hindrance to recovery theory. I was wondering if you could explain that a little bit more and whether that argument's been preserved.
Absolutely. The hindrance to recovery theory operates in a situation where there is a condition that's preventing the claimant from getting the treatment that is due to him or her by the employer carrier. If, for example, if there's out-of-control hypertension and the claimant needs to have surgery, well, the claimant's hypertension has to be under control in order for the surgery to go forward. So the employer carrier is required to treat that hypertension just to the point to get it under control so that the surgery can go forward, regardless of the cause of the hypertension. It doesn't need to have been there. If there was some indication that there is another condition here that is preventing the doctors in the Lowry case, in our case, from being able to provide the full treatment to the claimant, that hindrance would need to be removed, regardless of cause. So if there's a hernia there, and if it's causing a problem, and if it's causing the pain that these doctors are trying to solve and fix, and it's not related to the accident, there's still a possibility that the judge could award that treatment to remove an obstacle in order to allow for the proper treatment to go forward.
And so are you saying that the hernia could be a hindrance to proper treatment of symptoms that are caused by something else?
I'm not specifically making that because I would agree with you that was not developed in this record. I'm saying that the judge doesn't have to necessarily find on the causation in order to have awarded treatment under certain circumstances. We're not there yet in this case. I think we're at step one, which is let's get an evaluation. Step two is going to be, after that evaluation occurs, is this condition contributing to the symptoms that the employer carrier is providing treatment for? The next step is going to be, is there treatment necessary? Does treatment need to happen as a result of this condition that's been discovered? And then the last one is going to be, what's the cause of this condition? If they're hernias, what caused them? This case, as I mentioned, Granger is the case. The difference between Dixon and Wilson is that in Wilson, this is the case where they're treating one body part, but there's no overlap. They want an evaluation. They're treating the right shoulder, but the claimant is complaining of head and neck problems. But there's no indication that there's a crossover. There's no intersection between the complaints. There's no intersection of whether one is related to the other. And that's really where Wilson doesn't mesh well with the facts of this case. Dixon we sort of addressed because that has to do with claims that are mature and ripe. And the judge in this case didn't find that the claims were mature and ripe. So the JCC ordered a general surgeon evaluation and nothing else. That's the practical effect of his order. He did order diagnostic testing that are the subject of this appeal, that are also for that purpose to determine whether or not the claimant's condition, where the pain complaints are coming from. And Dr. Keller, who was the employer carrier's IME, put in his report, this is record 528, his IME report. In his impression section, he goes through all the complaints, he goes back through the history again, and then he says, he talks about the injections that are being provided or suggested to the claimant in another part of the order. And the judge finds Dr. Keller to be one of the more persuasive doctors. And after he goes through all these injections that are about to be provided, what he says is, what these injections do not address is the possibility of an inguinal hernia. But given the mechanism, it's not likely. So Dr. Keller doesn't think it's likely, but the testing that's otherwise being provided isn't going to cover this situation. The only thing that's going to cover it is the evaluation with the general surgeon. And that's what the judge ordered. There is no prejudicial reversible error, and this court should affirm the JCC's order. Thank you.
Opposing counsel's last point is that there's no prejudicial reversible error. But as we pointed out, the way the JCC wrote his order, it absolutely delegates the issue of MCC to a physician. Now, during his argument, opposing counsel basically says that, well, if the physician does in fact find that there is a relationship there, then the carrier can pay for it. He doesn't say anything about the carriers being able to dispute MCC. And in fact, in this record, there were 2 MRIs done before the claimant went to Shands and got that CAT scan. And in the report of the second MRI, the radiologist expressly states there is no hernia. So we have a clear difference of opinion, even if it's determined later on that there is a hernia and that there could be a relationship. But opposing counsel and the JCC have basically precluded the employer carrier from litigating that by virtue of the JCC's order saying if there is a relationship, then the employer carrier can pay. There's nothing in there about coming back to the JCC and litigating causation at that point. So I would submit that it's clearly prejudicial, the way the JCC wrote the order. I don't see that there's any way to read it otherwise. And certainly, had we not appealed this, we would have been barred by the law of the case from later on being able to argue, hey, we haven't had the opportunity, we haven't had the due process to litigate this issue. So we submit that on this record, we are entitled to a reversal, not just of the order on the evaluation, but also on the order of the ultimate determination of treatment being in the hands of some unidentified physician in the future. So we respectfully request that the court reverse. Thank you.
Thank you. Thank you to both counsel for your arguments today. council is ready, we will take the next case on the docket, which is Grable versus Grable, 24-3224. Counsel for the appellant, you may proceed when you're ready.
Thank you, Your Honors. May it please the Court. Welcome, Judge Treadwell. I'm Diane DeWolf for the former husband, appellant Stephen Grable. Your Honors, this is a very straightforward appeal. We have two issues on this appeal. We have case law that supports our argument 100%. Those two issues are an equitable distribution payment that's been delayed for 18 years. And the second issue is alimony that's inflated well beyond the former wife's need. And I'll take each one in turn. The trial court has discretion in how it fashions an equitable distribution payment, but it abuses that discretion when it postpones that payment for 18 years. We cited three cases directly on point on this issue. That's Harper, Thomas Nance, and the Gooder case. And all three of those cases say that there can't be a contingency on this payment, and we can't drag it out for decades. I think in the Harper case, it was a home equity of $25,000, where the court ordered payments for 20 years of, $100 a month or something like that. The courts have held that that's patently unreasonable, and that's exactly what's happened here. Now, former wife has tried to distinguish those cases by saying, well, in those cases, there was a small payment that was made every single month. Well, here we have no payments being made every single month, and we have a huge contingency on whether this is ever going to be made at all. First, former husband has to be around long enough to get to stop making alimony payments. Former wife has to be around long enough to do that too. And, alimony is a fluid concept, right? So, that it changes over time. It would have to stay exactly the same for 18 years. So I don't really know how you get around those cases. I don't think you can. And there are many ways to fashion this equalizer payment besides tacking it on to the end of alimony payments 18 years from now.
Let me ask, in terms of what the trial court's discretion is, is it your position that the trial court could have offset alimony the first 3 years as opposed to the last 3 years?
Well, that would probably be a little bit more reasonable. I don't think he could do it for an entire 3 years without also adding an interest component to that. So, right now, we are at, a year out. This is a November 24 order, right? Statutory interest in 2024 was 9.5%. So it's no longer 103 if we go by statutory interest. It's 113.
So what is the statutory basis for your argument that interest is an entitlement for this type of distribution scheme?
It's not an entitlement, and it's not a statute, but the cases that we've cited, this was also mentioned in Harper and also in Thomas Nance. If you're going to drag payments out, first of all, it has to be a reasonable amount of time. It can't be 18, 20 years like we have here, right? So it has to be reasonable. And you have to consider the interest component. Maybe interest, if it's going to be paid in 6 months or something like that, maybe interest isn't a component. But I suggest to you, when it's going to be dragged out after several years, there ought to be an interest component, and the case law supports that.
I'm just wondering what the basis in law is for the interest component.
Yeah, I don't know that that's in the alimony or the equitable distribution statute. I don't know that it's actually in there with the interest component, but the case law does support that. And Harper talks about interest, and also Thomas Nance.
So in 2018, the legislature did add a provision, subsection 10B, that discusses if installment payments are ordered, the court may require security and a reasonable rate of interest. Does that apply here?
I think it does. And again, it's a may, so it's a discretionary. So I don't think it's set in stone. But certainly, if you're going to have payments that, take 2 decades, and even 3 years, as you suggested, Your Honor, there should be an interest component. And again, as I was saying, there's several ways to fashion this. The former husband very reasonably said, let's just, instead of, leave my vector security account, let's not do it half and half, it's 103,000, so you take 103 less. The vector security was 400, so I'll take 303 and you take 97 instead of 200 and 200. But the court didn't do it. That wouldn't have been any money out of pocket to the former wife. But, Harper says there's any number of ways you can do this. You can require a home equity line of credit. You can require a second mortgage. You can require them to take out any type of loan to pay this. But the point is that it has to be paid, and it has to be paid now, not 18 years from now.
So to what extent does the court abuse its discretion by commingling this part, the equalizer, with alimony? It seems to me that they're separate and distinct, and maybe that's kind of the rub here, is then when you commingle it with alimony, it gets complicated.
It is complicated, and it's even more complicated if the alimony payments ended early for some reason, right? Because then the equalizer payment never gets paid, and you say, well, but the alimony ended early, so then you didn't have to pay as much alimony, and that's not the point. You still have an equalizer payment of $103,000 that's owed, and it was owed back when the final judgment was entered. It's not owed 20 years from now, whether or not, alimony lasts that long or not. So, very good point, Your Honor. No, it shouldn't have been commingled. They're two completely separate things. So we would ask on this issue that you reverse this equitable distribution scheme and order the trial court to fashion something reasonable where this gets paid in a reasonable amount of time with interest. Regarding the second issue, we have a $3,000 a month alimony payment that was ordered here that is at least 2 times and possibly 3 times beyond the former wife's need. Now, we know that before the final judgment, former husband was paying $1,140 a month in alimony that was later memorialized by the court. It was first voluntary. It was memorialized by the court. And former wife lived on that for a couple years. She did try at one point to come back and get $3,000 a month, and the court said, no, you haven't proved that you have a need for that, and he refused. And since that point, former wife hasn't gotten any more expenses. She doesn't now have a mortgage. She doesn't have any debt. There's no credit card debt, none of that. She got a raise, $3,600, but now all of a sudden, she's established this need for $3,000 a month, and I would submit to you that is not a need, that is a want. And we went through all of these in our brief, and I'm happy to go through them quickly again from her financial affidavit. I mean, and there's several items in here, and these were all brought before the trial court too, who just brushed these aside. But one, she lists $180 a month for health insurance payments, which is the premium for the entire family, adult children, and the former husband. The actual health insurance per month is $50 now, and she conceded that, and that's in the testimony.
Is it still your position that Mr. Grable should not be paying for the adult children's health insurance?
Well, this is state coverage, so yes, she's welcome to pay for the adult children's, but that shouldn't be credited as a monthly expense. That's a voluntary. And the $180 covers the entire family, including Mr. Grable. We have these $383 for monthly repairs and maintenance on the home. Again, if you look at that, the only thing that was talked about, one, was the house needs a new roof and a shower repair. Okay. But we all know that the value of the home was $290, and that wasn't from Zillow. That wasn't some, made-up number. That was a home appraiser that came to the home and did a home appraisal based on the shape the house was in at the time, taking into consideration that the roof needed repairs, right? So if the roof had been repaired, the house would have been valued at more than $290,000, and then the equitable distribution payment would have been that much more, right? Because she would have had a house valued at $300 and not $290, so she would have owed more. So, but she's added this, and it's completely speculative, and the case law says you can't do this either. You cannot have speculative expenses, and this is in the Dorworth case, and this is also in the Flans case out of this court. This is completely speculative. We have $383 per month for home repairs every month for 18 years, which at the end of the day is going to be $82,000. It's completely speculative. That's not a new roof. That's a
How
swimming
do
pool.
you make sense of the letter from the insurance company demanding a new roof? I mean, how can you say a new roof is speculative on this record?
What I'm saying is $383 per month for 18 years, adding up to $82,000 over 18 years. That's speculative. A new roof was already taken into consideration by the devaluation of the home to $290. If it already had a new roof on it, she would have been credited with a higher amount. That means that her equitable distribution payment would have been more.
How can we as a court ourselves speculate as to what something's value would be if a repair, would be made? Don't we have to take the present value of an asset and the equitable distribution side of the calculation?
I'm not asking you to speculate at what the value of the house would be with a new roof. My point is that the house was valued as it was, needing a new roof. So if she didn't have to do that, the value of the home would have been valued much higher. Does that make sense? I know I feel like I'm saying the same thing over and over. I'm trying to say it differently so it makes more sense. But she would have had a higher value asset on her side, okay?
Right, and I guess in the alimony calculation is what is the former wife's need, right?
Right.
And so is your position, had the, I guess, estimate of a home with a new roof been included, then the former wife wouldn't have that need? I mean, in some ways, I understand sort of your double counting argument, but at the same time, like, if she has to come out of pocket for a new roof, why wouldn't that be part of her need?
Because she got a devalued asset in the equitable distribution because she needed a new roof. Because the home needed a new roof. And either way, we're still looking at $82,000 over in home repairs over the next 18 years, which is, I mean, that makes my eyebrows go up. It should make yours go up too. The next category was car repairs. Now, we know that she had $4,500 worth of car repairs during the dissolution process, and that was not credited against her. $45 went to fix the car was fixed. So now she lists as a monthly expense, $398 per month for car repairs. The car's not broken. I don't know how else to say that except that it's speculative. We just have no idea, and no one should be spending $400 a month on car repairs. And again, over the course of 18 years, that's $86,000. So that's not repairing an old car, that's buying a Mercedes. Again, these are wants, these are not needs. And the trial court here, he took every one of former wife's listed expenses as gospel. He didn't question any of them.
Were they all objected to?
They were all objected to,
Okay.
yes. Even the food was objected to. I mean, monthly grocery bills of $850, that's for eating in. Then another $466 for eating out, that's $1,350 for a single woman per month. And none of this was questioned. And then the trial court said, that's probably not enough. I know that on your paper you say you need $27.14, but let's go ahead and round it up to $3,000 because you might have more expenses. So he gave her an additional $286 to boot. So if we take away the speculative expenses and the clearly inflated expenses, and we take into consideration that the former wife was living just fine on the 1140 for 2 years, and the court at that time found that she had no need to increase the expenses, with the increase in salary and no additional debts, it's just not possible that she needs, 3 times that much now.
Going back to the car repairs, I am curious how each repair in your argument is not, supported by competent substantial evidence. So, the first one I think that the former wife testified to was the catalytic converters. So she mentions that repair had already been made and was, an expense. How is that I mean, not competent substantial evidence as to
Oh,
what her car
it's
needed.
competent substantial evidence as to what has already been done. We don't have any objection to that. So her car needed repairs. It was $4,500 worth of repairs. Those were made during the dissolution process. That was not credited or debited to either party. That was taken out of the joint account. It was paid. What I'm saying is speculative, is she has included, for alimony purposes, for the next 18 years, $400 per month. That is $4,700 every single year for the next 18 years to repair a car. It's one thing to say, and that's speculative, okay, because maybe the car never breaks again. Maybe she decides to use Uber the rest of her life. You know, maybe she never gets another car. Maybe her parents give her a car, right? We don't know. It's one thing to say, I own a car, and my monthly expense is, you know, for my car payment is $350. That's one thing. That's something that's tangible. That's not speculative. But to say for 18 years it's going to cost me $400 for repairs,
Where
that's
are we
speculative.
supposed to draw the line in terms of, all right, an abuse of discretion standard, where are we supposed to draw the line? I believe the wife testified that she divided the house expenses over 5 years and the car expenses over 3 years. Where do we draw the line in terms of, you know, what amount of time is an abuse of discretion in terms of what you argue is inflating expenses?
Well, I think you really have to look at the case law and see what is speculative. It can't be an anticipatory expense. What she's saying is, I anticipate that I'm going to have to repair my car. But she doesn't necessarily have to repair that car. She may not have any car. You know, maybe we all go to public transportation in the next 5 years, right? So that is speculative. And the case law says you cannot do that. You have to have tangible, and again, it's the example of, I have a car, I have this payment, I have a mortgage, I have this payment, I have, you know, this is how much I make. Those are tangible things you can do. But alimony cannot be based on these speculative expenses that may never come to fruition. She might sell the house. She might never put on a roof. She might never have a repair. She might move in with her parents. These are all speculations, and that's where you have to draw the line.
Since you mentioned, you know, how much does she make, let's talk about the income piece. Why should we use sort of half the equation when, you know, she testified there in July at the final day of the hearing as to her then current income, or at least gross income? Why should we use that figure rather than the gross and net that she previously testified to on one of the earlier days in the hearing?
Because she got a raise. And we're calculating alimony from the final judgment. And between that hearing and the final judgment, she received a $3,600 increase. And, you know, that's not speculative at all. I mean, you all know as state employees, your salaries are online. My salary, when I was a state employee, was all online. You can look online and see what anybody makes who works for the state at any given time. So there's no speculation about that.
It seems like the parties, you know, there is no record evidence as to her net income there at the final day of the hearing, right? And so that's why there was this argument about what tax rate applies. At what point should we, you know, say, okay, the trial court has cut off the admission of evidence, and so we use what's fully in the record in terms of net income versus, you know, did the trial court have a duty to keep the record open, to get a first pay stub? I mean, help us sort of analyze this issue in terms of the record closing.
Well, she was asked at the hearing, did you receive a raise? Is this now your salary? And she said, yeah. So I think all those numbers are fluid until the final judgment. And I see I've almost depleted my time, so I will save my minute
Thank you, counsel.
for rebuttal. Thank you.
May it please the court. My name is Eric Schopp, and I will be presenting argument today on behalf of the appellee, Melissa Grable. I'm going to be presenting argument in the same way that the briefs are structured. I'm going to start out by addressing the appellant's challenge to the equitable distribution, and then move on to the issue of alimony. When it comes to the distribution, the appellant's only challenge to that is the method of the payment of the equalizer that the court fashioned. I think the case that really is this court's guiding light when reviewing the reasonableness of that payment method is the Knakeris case from the Florida Supreme Court in 1980. I trust this court is very familiar with that case, but it essentially describes the parameters of the trial court's discretion in dissolution of marriage cases. Essentially, the Supreme Court described that so long as the trial court's decision could be considered reasonable in light of the evidence presented, then the trial court did not abuse its discretion. Where I quoted specifically from that case in my brief was where the Supreme Court said, dissolution proceedings present a trial judge with the difficult problem of apportioning assets acquired by the parties and providing for necessary support. The judge possesses broad discretionary authority to do equity between the parties and has available various remedies to accomplish this purpose.
So counsel, thank you for refreshing our memories, and we are very familiar with that case and those principles, and so certainly discretion is always bound by the law. So let's focus on the law. In terms of equitable distribution, the equalizer payment was due immediately, or became due immediately, correct?
I would agree with that.
So how do you reconcile that with this idea that it somehow becomes commingled in alimony, which in some hypothetical situations, it could never become due?
If you'll let me finish my quote from Knakeris, I'm getting right to that exact point, because what they go on to say is that these remedies are interrelated. And so it's important when an appellate court is reviewing the trial court's decision to review that as a whole and not to kind of look at
Excuse me, Counselor. Knakeris was decided in 1980. The legislature passed the equitable distribution statute in 1988. So is on that point, if there's a conflict between the equitable distribution statute and Knakeris, which one should win out?
The statute would govern. As I understand, when that statute was passed in 1988, it essentially codified Knakeris. That was the intent of it. And obviously that's been built upon and, developed in the 30-odd years since then. But yes, the statutory authority, I agree, would govern over Knakeris. However, as a principle of law, I think that is still kind of the guiding light behind the court in this case. Now, to get to Judge Ray's point, and I'm sorry I took a little detour on the answering the question there, I just fundamentally disagree with the characterization put out by the appellant that he has to wait 18 years to receive his equalizer in the way that this was all fashioned. And I can get through the process of how we got to this point in the record of why, the court chose this payment method as opposed to other payment methods. But I really think he's already gotten the benefit of it in the form of an alimony award that is shorter than what it would have been, and is also probably less than what it would have been otherwise. Because when you go through some of these other options that the appellant has put out there, the trial court could have done this, they could have ordered this. There are very specific reasons why in this particular case, those options really weren't available to the trial court based on the arguments that the parties made and the evidence that was developed on the record at the trial. And really, when you got down to it, by the time we got to final hearing, the only two options available to the court were to do some kind of an offset of Mrs. Grable's alimony award, or essentially require her to pay all of it immediately, which probably would have required her to take out some kind of a loan or go into debt because she wasn't being awarded the liquid assets to be able to make that kind of a payment, which would have then increased her need for alimony by the amount of the loan payment, right? Because if all of a sudden she's got to take out a debt in order to pay Mr. Grable his equalizer, well, then that's kind of circular, isn't it? It's going into a situation where he might end up paying his own equalizer in the form of an increased alimony obligation based on the issue of her increased need. So to give you an example, one of the options put out there on appeal by Mr. Grable as what the trial court could have done as opposed to what he actually did in this case was require the home to be sold. Well, that wasn't really a realistic option for the trial court in this case. First of all, neither party pled for partition in the actual pleadings themselves. And then second of all, from the very first day of trial, at opening statement, it was stipulated by both parties that Mrs. Grable was going to be awarded the house. We didn't know exactly how things were going to fall around that, but it was, stipulated from the front end. I think if the trial court had departed from really what both parties were putting on the record as what their position was and asking him to do, that would have created more appealable issues with the equitable distribution scheme than what he finally did. Another topic brought up today by opposing counsel was the idea that there could have been an offset. Maybe my client could have taken a little bit less from the 401k and had that paid immediately rather than doing what the trial court ended up doing in this case. And I thought that was an interesting suggestion because you'll see in my brief, that was actually our position on the very first day of trial, was as a starting out point, was we were actually proposing that as a solution to deal with that problem. However, what ended up happening is after the first day of trial, Mr. Grable hired an expert accountant to testify about the retirement accounts, how they should be divided, and specifically issues with tax consequences, potentially valuation of my client's pension, and things of that nature. And what that expert ended up recommending that the trial court do by the second full day of trial, which was in March of 2024, was divide all retirement accounts evenly on a pre-tax basis, and then handle the rest of the distribution separately. The trial court ended up going with that accountant's recommendation, and my client, or Mrs. Grable, did endorse that at the last day of trial when she testified on rebuttal. But when the trial court decided to adopt that approach, it really removed the retirement accounts from the rest of the distribution. And then so there really wasn't another asset like that that could be kind of used as an offset. And when that happened, it created a situation where we really weren't able to do an offset against some other piece of the distribution. And then we were left in this situation where there were really only the two options of Mrs. Grable incurring some kind of debt, getting into this problem that I talked about already, or doing an offset against alimony. As I raised in my brief, the position suggested by both parties to the trial court was an alimony offset. The difference in what we were proposing was not one of character, it was one of degree. The appellant, in his proposal to the trial judge was just saying, look at that as a lump sum payment of alimony and then nothing else is owed since then. We'll do that as an offset there. Our position was that could be an offset against a portion of the alimony award, but it's not an offset of the entire award. So the trial court really took the approach that both parties were advocating for at the trial level. Now, he ended up closer to the appellee's position than he did the appellant's position overall at the end of the day, but I don't know how you could argue that the trial court acted unreasonably in adopting this particular approach when it really was something that was in the middle of the two different approaches that were being put forward by both of the parties. So when you look at it...
It makes sense how we got here. I mean, the story makes sense. But in terms of our review, in terms of the abuse of discretion standard of what is now before us, I mean, would you agree that if your client were to remarry or pass away, that there's a likelihood that the appellant would not receive any of the equitable distribution?
Well, I think this kind of gets into your first question that you asked the appellant at the beginning of the oral arguments, which is, would you say that there was a problem if he got paid up front, whether getting paid on the back end, and how some of that was kind of worded in the court order? My position is he's already been paid, in a sense, in that, you could look at this as just a lump sum award of alimony is basically wiping out the equalizer, and then the durational alimony award is shorter than it otherwise would have been and lower in amount than it otherwise would have been. So if he's already been paid, I really don't think there is any danger that he would go without his equalizer. Whereas the appellant is trying to frame this as he's not going to get paid or be compensated for this for another 18 years. And I just disagree with that characterization.
If your client remarries, let's say at year 12, what does it matter whether the alimony award is 15 years, 18 years, or more? I mean, obviously, the cap is 18 years, but what does it matter? I mean, how could you say he's already been paid if your client remarries at year 12?
Because, so for example, if he were to be, if we were in a world in which my client was required to pay him the equalizer up front, borrow a loan, take out the money to actually do that and start paying him. Let's say his alimony award was $3,500 a month rather than $3,000 a month, taking into account her increased need to have to do that and, taking into account that there probably would be interest paid on that if it's a loan through a bank. So every month so far that he's been obligated to pay $3,000 a month as opposed to, say, $3,500 per month to account for what her need would be with that loan payment, he's effectively getting the benefit of the alimony award that the court actually did fashion.
And maybe just to jump off on Judge Treadwell's question, though, this again, it shows the complications with commingling the equitable distribution payments with alimony. It gets complicated, and no matter what hypothetical scenario we throw out to you, I think it becomes problematic. So why isn't that in and of itself an abuse of discretion? Maybe you've answered the question that both parties suggested to the court, that alimony be fashioned in some various ways to accomplish the equitable distribution. Is that correct?
That's part of my answer to that question, Your Honor, is that I do think, when both sides are suggesting, an alimony offset is a reasonable way of accomplishing the equalizer, then you're looking at this from a standard of, okay, could reasonable minds disagree on whether or not this was the right course of action to take? I think that answers that question right then and there, that clearly reasonable minds could have thought that this was the approach that the trial court should have taken, because really both parties suggested it to the court. It was, what he ended up doing was something that was a mix of what both parties had suggested. So when you're looking at it from that abuse of discretion standard, I don't see how you say that the court abused its discretion when it really adopted an approach that was along the lines of what was offered to it by both parties.
I did not see in your briefs a position on the interest argument.
Well,
Care to
I don't think
comment
you
on
get
that?
into the interest argument if you just affirm the trial court's position as it is. Now, I would agree with Ms. DeWolf that in a world in which the trial court instead ordered my client to pay $103,000 to Mr. Grable in monthly installments of $500 per month, he would have also had discretion to award interest on that payment. But since we are taking the position that the trial court's ruling should just be affirmed as it is, I didn't see a need to get into that argument specifically. But I do agree that if there is a different distribution scheme, depending on, say, remand or something, then it would be appropriate for the trial court to consider statutory interest.
Great. All right, the alimony issue.
All right. I'm going to move on to the issue of alimony then. So on this issue, the appellant challenges really two of the trial court's findings. The first is related to Mrs. Grable's income, and then the second is related to her monthly expenses and her need for support. So I'm going to go through them in that order. Again, I think the guiding light here ultimately goes back to Canacaris, but the case that I cited in my brief on this, I think it's called Theriault, I think I'm pronouncing it correctly, which is out of the first DCA in 2012. It's citing Canacaris, though. And what it generally stands for is that this court's decision should be affirmed if it's based on competent and substantial evidence and does not cause either spouse to pass automatically from misfortune to prosperity or from prosperity to misfortune. So I think that's kind of the guiding principle here for evaluating whether or not the trial court's decision in all of this was reasonable. So as to Mrs. Grable's income, I think it's important to review the timeline of the final hearing itself. We were originally set for a full-day final hearing at the end of November of 2023. We did not finish that day, and so 2 hours were reserved in December to finish up the trial. During that time, the appellant decided to hire an expert. And so that caused a delay of the final hearing until March of 2024. Again, we did not finish that day, and so the final portion of this was set for July of 2024. During the July 2024 portion of the hearing, Mrs. Grable testified in rebuttal to some of what the appellant had been presenting on the record, regarding the various issues in the case. During cross-examination of that rebuttal testimony, the appellant's attorney asked Mrs. Grable some questions about a raise that she had received about a week before the last day of the final hearing. She didn't even have a pay stub yet, regarding what all of that looked like. There was no concrete information presented as to exactly what that gross amount was. The attorney for the appellant at the trial level just put out a number, and my client said that sounds about right, I think was about what the transcript said, but kind of equivocated on that, and there was absolutely no evidence presented as to what the actual net income would be. The trial court, in its discretion, based both parties' incomes on their 2023 income information. That decision makes sense, given that it had the most accurate and complete information for that year. What appellant is suggesting this court should have done is conducted its own independent research using publicly available information to get an exact figure for my client's income as of the last date of the final hearing, and then either come up with its own math to figure out the net income, or sua sponte, because no party actually requested this, continue the final hearing to a 5th day to allow additional discovery to see what the actual net income would be and additional discovery on that issue. I think the sound approach here was the one that the trial court took, and it based the parties' incomes on the actual record before it, the 2023 data, which was current as of the time the trial commenced. I think there actually would have been more appealable issues if the court had gone outside the record and done its own research as suggested by the appellant.
So within the record, and I'm looking at page 1458, within the record, the question to your client was, can you verify that your present income is presently $46,456 annually? Answer, that is probably correct. Yes, sir. So if your client is acknowledging that her income is different than what's in her affidavit and what's on the pay stubs that were previously, admitted into the record, why wasn't it an abuse of discretion for the trial court to use the outdated figures, at least on gross income?
I think her exact quote was, "It is 46 something." So that sounds right, yes, sir.
So that was the colloquy with the judge on page 1459. But if you look at her initial answer with 1458 before the judge got involved, I mean, that seems like an unequivocal acknowledgement, admission. That is probably correct. Yes, sir.
Mhm.
And even if her testimony was simply, yes, it's now 46,000 something, why wasn't it an abuse of discretion for the trial court to still use a $43,000 figure?
Well, because the court had the actual net income figures from the 43,000, the earlier figure, which net income is what you need to use for alimony purposes, and establishing that figure. It had no information about what her new net income was, even though there had been this raise.
Have circumstances changed since then? Either
Since
side? I mean, if we send it back, is it a do-over? I mean, are we still using the old numbers? They get a chance to put on the new numbers, everything's different. We do it again, we see you in 18 months, what's going to happen here?
Well, I think that was the trial court's concern, was that this trial had already been ongoing for about 8 months at this point, and rather than kind of leaving the record open, and I'm not sure to what extent this is in the record, but we had actually filed for additional discovery from Mr. Grable in the month of January. We filed a motion to compel. The court denied it. I think he was trying to close the record to kind of just get something that was static in time, to try to, have that to calculate alimony, because these numbers do fluctuate.
I mean, and that's inherent in the process, for both sides. It's just the way it happens, but yeah.
So I think, obviously, if you were to go on remand, probably the numbers would look a little bit different today on both sides. I'm not, necessarily arguing that, but I think at some
And
point.
nobody's stuck with the old numbers, provided that they provide new numbers, if there's a do-over.
Right.
Okay.
The next and final issue is my client's estimated expenses for various things that the trial court used to calculate her monthly need for alimony. And when I first read through the appellant's argument on this point, I felt like he was talking out of both sides of his mouth. On the one hand, he's arguing that the trial court shouldn't have looked backwards at an average based on past expenses because those had already been paid. But then on the other hand, he says you can't look forwards to reasonably anticipated future expenses or events. I mean, by his logic, I feel like the trial court would have had to have boxed Mrs. Grable in to the date of the final hearing and only counted the bills that were actively due on that date and time. I see my time is coming to an end here, so just to kind of wrap this up,
Well,
I do
counsel,
think.
I'll extend your time and then provide
you.
the same courtesy to appellant's counsel. I do want to just ask about these additional home repairs and maintenance, the roughly $286 a month that were kind of added on. Do you concede that there was some double counting there based on what was already in the affidavit, or do you see a distinction?
I believe there is a distinction there, and I think what's also important for this court to understand is we had done 3 different financial affidavits over the course of the case. Most of those had figures over $3,000. The most recent one was the one that had the figure with a number that was a little bit over that. From the first day of trial, though, my client testified to a need of $3,000. What's in her financial affidavit was based on, certain reasonably foreseeable expenses. There was testimony about the average and how she kind of got that number there. She also presented testimony about various different unexpected expenses that had arisen while the matters had been pending. I think there was a garage door repair that was testified to during the course of this, and some of that is what is informed in that additional number that got us from the number that's on her financial affidavit to the $3,000 that was ultimately awarded by the trial court. So I don't think it's double counting. I think it's kind of, these were specific itemized things, and then there was kind of but there were more things
But like a
that I
catch-all,
wasn't
something like
anticipating and
that.
wasn't counting. That's, yes.
Yeah, so the trouble as a reviewing court is we're tasked with connecting the dots, and it's really hard for us, or at least for me, to connect the dots when we have kind of this catch-all sum that at least on paper, based on what I can see, there does seem to be some redundancies. So I guess I'm just, stating that proposition that I'm having a hard time not seeing some redundancies, at least with respect to that extra amount that was added on.
And I think that's where we get into the Kanakaris case, as quoted by the first DCA and Theriault, that I started this whole portion of the argument out with, which is, a lot of the appellant's argument is kind of digging in through little expenses and trying to see exactly if all the numbers add up or not, or this or that or the other thing. But I think the standard that this court needs to kind of look at is there competent and substantial evidence in the record to support what the court ultimately ended up doing? And is it an award that, doesn't, immediately move one party from being impoverished to prosperity or vice versa? And I think the court's ultimate award here of $3,000 per month in alimony is in that middle ground of, kind of giving my client the support that she needs to live with some standard of living comparable to what was, she was accustomed to during the course of the marriage, while also not being so burdensome on the appellant that he's now at this reduced standard of living where he can't live the same way that he did before. I think the court's award here is in that middle ground, and so I think it is within the bounds of his discretion, regardless of...
Sorry, on the additional home expenses, and you mentioned the garage door that happened,
Yeah.
pending the final hearing's conclusion. How should we sort of read the colloquy here on record page 1429 between the court and trial counsel for the appellee, where the judge is inquiring about the affidavit? But what I'm trying to get at is when the wife sat down and did what she thought were her expenses, was she thinking, no, it should include reasonable expenses for breakage of things, roofs and water heaters, things that happen? Trial counsel answered yes. So is there competent substantial evidence to suggest that what she put in her financial affidavit is not all-encompassing of every house repair that, may come about?
I think there is competent substantial evidence. I understand the exchange that you're talking about right there. However, I think there is plenty of testimony actually in the record from Mrs. Grable during all of the final hearing about additional expenses, on things that she didn't foresee when she prepared that financial affidavit that were included and kind of factored into that $3,000 number.
Thank you, counsel. Does the court have any additional questions? Thank you.
Thank you all so much.
Two quick points, Your Honors. Both sides did not suggest that this come out of alimony. The only argument that former husband made regarding alimony was, hey, you owe $103,000. Why don't you just take it as lump sum alimony, and then we'll just wash our hands and be done. No one suggested that it should be over a 3-month period, for a 3-year period, or at the beginning or at the end, or anything like that. So no, this was not an argument made by both parties. Mr. Grable made several, suggestions as to how this equalization payment could be made, and it wasn't as far as I know, the IRA accounts still haven't been split. So no, that's not off the table. At any time, this can be done to affect the equitable distribution as it should have been done in the first place. And the second point I wanted to make was, the point that counsel was making about alimony, how the court just sort of split the baby, right? He just picked a middle ground. He doesn't get to do that. The case law says that alimony must be based on need, and it cannot exceed need. And this is the Flans case and the Dorwith case. In both those cases, the husband, I think this is the Dorwith case, the husband's annual income the last few years had been $500,000 per year. The wife's income had been $52,000 a year. They came up with what her monthly net income was, and they had awarded her $5,000 a month. And when they looked at the end of the day, they said, look, you have shown a need of 53 or 57, but with the alimony that you've been given and your income, now you're getting 73. That exceeds your need, and we can't do that. That's an abuse of discretion, period. It's based on need. You don't get to pick a middle number. And if you don't have any questions for me, we would ask that you reverse this on the two bases that we've talked about today and ask the trial court to formulate a reasonable, equitable distribution scheme now and to reduce the alimony accordingly based on the former wife's needs.
Thank you, counsel. Thank you, counsel,
Thank
for
you.
both parties. We appreciate your time. The court is now adjourned.
All rise.